Welcome back, everyone. It's Peter Tragos, the lawyer you know, and today we're going to break down the Kim Potter sentencing. The Minnesota police officer who accidentally grabbed her gun instead of her taser and killed a young black man at a traffic stop. Trial happened a little while back. They are now finally getting to sentencing, and she was convicted of an accidental killing. She did not intend to kill. And that is a big deal when we talk about this sentencing. And as always, we're going to hear a lot from the judge in this sentencing. We're going to hear what the judge felt about this case. We're going to get a pretty good idea as to how the judge was leaning throughout the trial, because there were some comments on both sides about this judge's demeanor, kind of the balls and strikes that she called during the trial. But we are going to get a pretty good look into how she felt about this case in the sentencing phase, as we always do. And some of you all in the other cases, like specifically Ronnie O'Neill, had some thoughts on whether or not it was appropriate for a judge to make such comments that let you know where she's standing in the sentencing phase. So where we're going to jump into this video is when the judge starts discussing what the sentence is and why she came down with the sentence that she did. We're also going to hear her compare it to a couple of other cop killing cases. So we're going to hear her differentiate or make them similar to Kim Potter's case, and then we are going to hear the sentence. So if you've been following along this case from the beginning with us, you've probably already subscribed to our page, but if you haven't, go over there, hit the subscribe button so you can follow along with all the cases we're following. Hit the like button if you enjoy the sentencing breakdown, and let me know in the comments whether you think this was a fair or unfair sentence and which way, because I've actually heard people on both sides complaining this was too harsh of a sentence and this was too light of a sentence. So it's very interesting when a sentence like this comes down, because we've seen some arguments on both sides. So I want to hear what you, the viewer and potential juror, think about this sentence. And at the end of the video, we'll talk about how this could affect appellate issues and future steps in this case for Kim Potter. So as we jump into sentencing, a little bit of context is important. The state brought their evidence of why this was such a severe case, why this deserves 7 years, which is what they're asking for in prison, which is kind of a common sentence in a case like this. It's not a horrible sentence. This isn't one of the worst they've ever seen. They didn't make it kind of go that route like we saw in the Derek Chauvin or Ahmaud Arbery case, where they really wanted to hammer these defendants. They asked for kind of a normal sentence of 7 years for these crimes. Keep that in mind, because a lot of people that are arguing that that's too light, think she should be in prison for the rest of her life, death penalty, horrible punishments, but not even the state attorney in this case was asking for a max penalty. They were asking for 7 years, and as usual, the defense attorney was asking for probation only. So will the judge split the baby? Where will she come down? We'll listen to it, but not just the sentence that's important, but everything surrounding it, especially the judge's explanation as to why she delivers the sentence that she did.
Okay, this is one of the saddest cases I've had on my 20 years on the bench. On the one hand, a young man was killed, and on the other, a respected 26-year veteran police officer made a tragic error by pulling her handgun instead of her taser.
So I'm going to pause right there. It gives us context from the jump. She said this is the saddest story, one of the saddest she's seen in 20 years on the bench, because a young man's life was lost, but also a 26-year respected law enforcement officer made this tragic mistake. So giving some benefit to the defendant. The judges don't always talk about defendants that way. She also gives us indication that the factual finding is she accidentally grabbed the gun when she meant to grab the taser, which shows she had no intent to kill. This was accidental, which is very important as we continue to listen.
Thank you to everyone who spoke. I have been profoundly moved by the comments of the Wright family. Daunte was very loved. His son has lost a father, and Mr. and Mrs. Wright, I cannot begin to understand the grief of losing a child. I'm so sorry for your loss. Kimberly Potter honorably served her community for 26 years as a police officer She was a respected officer and consistently went over and above the call of duty. She's a wife, a mother, an aunt, a granddaughter, a colleague, and a friend to many. In addition to the letters that were forwarded to me by Mr. Ng, I received hundreds and hundreds of letters in her support from colleagues, family, friends, acquaintances, community leaders and members, and even strangers.
That's big. Not only the letters and the comments submitted by her lawyers, but also people went out on their own and stuck up for Kim Potter and sent letters to the judge. It's a pretty good indication of her character. I mean, not even asked to do this, and they went above and beyond to make sure the judge knew what kind of person Kim Potter was, and that had a profound effect on the judge. And what you didn't hear, if you're looking at the video, we're an hour and 45 minutes in, a ton of people testified, including Kim Potter, who gave a tearful, sobbing apology to the family. Did not seem like she was afraid that her admitting that she made a mistake and did kill him was going to affect her sentence or affect her conviction. If she wins on appeal, this could be used against her in a second trial. It did not seem like she cared about that with the statements that she made. And if you want me to do another video breaking down her statements, let me know by putting Kim's statements in the comments. But for now, we're really going to focus on the judge's thoughts on this case and the sentence she brings down.
I read them all. They paint a portrait of a woman who touched a lot of people in a good way. I want to talk briefly about the aggravating factors that were brought up in this case.
So every case and every judge when determining a sentence has the aggravating factors that makes it worse and should get a harsher penalty, and the mitigating factors that make it better and less of a penalty. So she's going to go through the aggravating and mitigating factors. And this is all on the record, and that's why that's important. In case the sentence is appealed, the appellate court will have all of the reasoning as to why the judge handed down her sentence. That's why she puts it all on the record and actually goes through what the aggravating and mitigating factors are.
As I mentioned before, the state initially took the position Ms. Potter should receive a sentence above the guidelines and filed a brief in support of two aggravating factors under Blakely. All parties agreed that I would determine whether aggravating factors existed to justify a harsher sentence than that set forth in the guidelines. I feel compelled to address the grounds for that request because they were made public, and I think it is important to note they were not proven in this case. The state did not meet its burden of proof on the first factor. It is based on defendant causing a greater than normal danger to the passenger in the car and two other officers when she fired. But the shot only hit Daunte Wright. The passenger and the officers were not injured by that shot. The cases cited by the state in its brief did not support its position. In fact, they illustrate why this case does not involve a greater than normal danger to others.
So that's really interesting in context of Rittenhouse and even the Curtis Reeves case, where they charged them with endangering others. And in Reeves, they just charged him with endangering the wife who was actually shot in the hand. But in Rittenhouse, there were other people that weren't actually hit or maybe were hit in McGinnis. And the judge is saying, if no injuries occurred, no one was hit, you didn't meet your burden, state, for endangering others like the two other police officers and the passenger in this car.
In the Fleming case, he fired a gun 6 times in a park filled with children. In State versus Omaha, defendant fired numerous shots into 2 apartment buildings. There is no comparison here.
So you're getting a little peek into what a legal brief is like and what lawyers do. They cite cases, they pick parts from that case to explain their point of view and their position. The judge, the other side gets to respond. The judge has to analyze it and make a decision. And she either has to say, is this case the same as those other cases? Because if it is, I need to make the same decision the judges made in those cases. But if this is different, if I can differentiate this Kim Potter case from those other two cases, I don't have to follow what the judges did. I need to make a decision that is correct for this case. And that's how it works. That's how the law works. That's what precedent is. That's what using prior cases is and prior decisions are. This is what it's like to write a brief and convince a judge of your position. And this is what it's like for the judge to do that analysis and make a decision. And here she's saying it's different than the cases the state cited.
The state also did not meet its burden of proof on the second Blakely factor. Contrary to the state's claims, Kimberly Potter did not abuse her position of authority. In fact, it is undisputed Ms. Potter or Officer Potter was in the line of duty and doing her job in attempting to lawfully arrest Daunte Wright on the warrant when she mistook her gun for her taser. What's more,
so that's interesting, saying she was in the line of duty and what she was doing was okay. Basically, a lawful arrest is what she was trying to do. Basically saying the use of force of her taser would have been fine, which I kind of think was the common theme throughout the whole trial, but use of force with the gun, not okay, and that mistake was the deadly difference for which she was convicted. And throughout this trial, I kind of thought it might be a not guilty verdict, but I could have seen this one going either way and was kind of okay with it, legally speaking, going either way because of the accidental killing. And we'll talk more about that based on what this sentence is. But the judge is saying she did not abuse her power. Again, differentiating it from some other cases that we are very familiar with, and she will mention by name eventually.
she drew her taser legitimately to protect a fellow officer on the other side of the vehicle who could have been dragged and seriously injured if the car were to speed away.
So she bought the defendant's argument that the car can cause serious bodily injury, and the car could have caused serious bodily injury to her other officer. Now, to me, almost sounds like the judge is going far enough to say deadly force was okay in this case. Almost sounds like the judge is saying she did have a reasonable belief that her colleague, the other cop, was in danger of serious bodily harm because of this car, which would have made even using her gun legitimate and justified in the shooting. That's what it sounds like the judge is saying. The judge is using this argument to say that there's no aggravating factor for abuse of power, but at the same time, she's almost saying that this was a justified self-defense shooting. Very interesting comments.
Officer Potter's conduct clearly was not significantly more serious than that typically involved in the commission of the crime in question, justifying an upward departure. Turning to defendant's request for a dispositional departure, there is no question that Ms. Potter is extremely remorseful. She showed that today. She showed that when it happened. It is also beyond dispute that she is particularly amenable to probation.
Particularly amenable to probation gives an indication the judge might just give her probation. No jail time. She has switched to the mitigating factor. She's not going to do an upward departure. Defense asked for a downward departure. Let's talk about whether I'm going to do that. And then now she's getting into the mitigating factors, one of which is remorse. A second one is, will probation rehabilitate her? That's a big question, because sometimes when you've got career criminals, the judge looks and says, I don't think probation is going to help this person. They've been given chance after chance. The judge is saying, I do think probation is going to help Officer Potter. So will she just give probation? I assume most of you know what the sentence is already, but if you didn't hear the judge the entire time and you didn't know the sentence at this point, if I was reacting live, I would think, is she going to give probation at this point? That's what I'd be thinking.
But the court retains the discretion to make departure decisions independently. The court is not required to depart even where mitigating factors are present, and that's set forth in State v. Birch 689 Northwest 2nd, 276, affirmed by the Supreme Court, 707 Northwest 2nd, 660. This has been an extremely difficult decision.
It sounds like the judge is getting choked up.
In making my decision, I look to the purposes of incarceration. There are 4: retribution, incapacitation, deterrence, and rehabilitation. 3 of the 4 would not be served in this case.
All right, so that was important. The judge just read the 4 reasons for incarceration and immediately follows it up with 3 of those reasons would not be served in this case. Meaning the purpose of incarceration is not going to be in effect for Kim Potter. So she isn't really a good candidate for incarceration is what the judge is saying at this point.
Incapacitation refers to the physical removal of a convicted person to prevent them from committing future crimes. That is not an issue in this case. Kimberly Potter does not present a danger of future crimes, obviously. Deterrence refers to the prevention of future crime and the idea that those who have committed crimes will be discouraged from reoffending after experiencing punishment. That purpose would not be served here. Rehabilitation is also not a purpose that would justify incarceration in this case. Ms. Potter does not require rehabilitation to become a law-abiding citizen. Retribution, or serving time as a way for a convicted person to pay for the harm inflicted on a victim.
All right, so before we get to retribution, which is for Potter to pay for her crime and the harm that she caused to the victim, right? Because that's the one I think she's going to say, this judge is going to say makes sense for Potter to be incarcerated. But this is very unusual. And a lot of you are following some of these high-profile cases, especially with law enforcement officer defendants, especially most of them have no prior convictions, no criminal history. Judges do not usually speak this highly of criminal defendants. Usually when they go through these factors, they say all 4 kind of heartlessly apply to this person while the criminal defendant is just waiting to see how long they're going to be in prison. But Kim Potter's wondering at this point, am I even going to go to prison? But now we get to retribution, which I think, and let me know in the comments, those 4 factors, right? Let me know if you think that that more than one applies to her. Does she need rehabilitation? Is she actually going to be a danger to society? Is she going to commit another crime? Do we have to be worried about that? Does she need to be removed from society? Let me know, because I agree with the judge. I don't think any of those really match Kim Potter, but I do believe the reason I was okay or understand why she was convicted, and the only reason why I can understand if she gets a criminal punishment here, is because of the damage done to the family. Because her mistake ended tragically, similar to the truck driver who got 10 years. Killed multiple people, injured even more because of his bad decision making. Same thing here. So if she is convicted of that, this is the only reason I can see for incarceration, which is what the judge is saying.
Is the sole purpose that applies in this case. And in this case, a young man was killed because Officer Potter was reckless. There rightfully should be some accountability. Sentencing guidelines are just that. They are guidelines that inform a judge regarding sentencing for various crimes. They are not set in stone. The court has the discretion to depart from guidelines depending on the particular facts of a case. A downward durational departure is justified if a crime is less onerous than typical. Put another way, if the conduct is significantly less serious than that typically involved in the commission of the crime, sentencing below the guidelines is justified. I find the facts and circumstances here justify a downward departure from the guidelines. First, Officer Potter's conduct was significantly less serious than your typical manslaughter case. The misdemeanor predicate for the manslaughter count was reckless handling or use of a firearm. Here, everybody agrees, and the evidence is undisputed, that Officer Potter never intended to use her firearm. She mistakenly drew her firearm at all times, intending to use her taser. There were police officers and experts who testified that the use of her taser was reasonable and appropriate under the circumstances presented for officer safety reasons.
Again, use of taser, totally reasonable, according to all the evidence. It's not necessarily something the jury had to decide, but what she was convicted of was completely accidental. Not something she intended to do. Not a depraved heart. Not an evil heart. Not an evil intention. Instead, it was a good intention to protect her fellow officers. So it makes a big difference, people's intentions, right? We have actions and our motivations for those actions. Her actions were bad, but her motivations for those actions were not bad. It was the mistaken action that needs to be punished, not her decision-making necessarily. Because she made the right decision, made the wrong move, grabbing the gun instead of the taser. And whether or not, I know a lot of people are going to argue, how could you possibly, the taser and the gun look nothing alike? How could you possibly think that? Well, according to the judge, all the evidence pointed to, she meant to grab the taser and accidentally grabbed the gun. So that's kind of in the past. We're starting from there.
The fact she never intended to draw her firearm makes this case less serious than other cases. Second, the scene was chaotic, tense, and rapidly evolving. Officer Potter was required to make a split-second judgment. That constitutes a mitigating circumstance.
And that would have been something in the Rittenhouse case had he been convicted. That was another purpose for all that testimony about split-second decisions and a chaotic environment. So there are a lot of similarities in these cases, which is how we use one case as research and backup and explanation and argument in another case.
Finally, unlike other manslaughter 1 cases, Officer Potter's actions were not driven by personal animosity toward Daunte Wright. Instead, she was acting in the line of duty in effectuating a lawful arrest. This case is highly unusual. The other officer cases tried in this court are distinguishable. This is not a cop found guilty of murder for using his knee to pin down a person for 9.5 minutes as he gasped for air.
We all know what case she's referencing, the Derek Chauvin case. She says this is not like the Derek Chauvin case where he put his knee on a man's back and suffocated him for 8 minutes or whatever it is that she said. She is saying this is not like that. This is nothing like that. This sentence is not going to be like that. I'm distinguishing this from that case. She's making that clear from the jump, which is not the one most people have a problem with. The next one she's going to reference is who you're going to see people talk about in the media, say this is so unfair, this is a racist sentence because of this case she's about to distinguish right now.
This is not a cop found guilty of manslaughter for intentionally drawing his firearm and shooting across his partner and killing an unarmed woman who approached his squad.
So that case was a black male officer who drew his gun intentionally and fired his gun intentionally in the line of duty, trying to protect his fellow officer, similar circumstances, but he intended to grab his gun and fire his gun, versus Potter intending to grab her taser and fire her taser, which is a much different thought process and psyche on recklessness and how you're affecting everyone surrounding you. If you know you're shooting your gun, officers are trained that if they know they're shooting their gun, that's as dangerous as it gets, and you better make sure nobody's around to accidentally get hit. If you draw your taser, it's a little bit different. So her mistake was drawing the taser. But this male officer that she's referencing here and distinguishing intended to draw and shoot his gun, and an unarmed white woman was killed. So that's why a lot of people in the media are saying this is racist, because the black male cop who shoots the white woman gets a much harsher sentence than the white woman cop who shoots the black male. It's exactly reverse gender and race. So that's what a lot of people are pointing to. But legally speaking, the factors are different. They just are. And this judge is laying that down on the record, saying this is different from that case. So you may agree with it, you may not, but she is factually and legally distinguishing these two cases before giving her sentence.
This is a cop who made a tragic mistake. She drew her firearm thinking it was a taser and ended up killing a young man. Ms. Potter, will you please rise?
Again, it seems like the judge gets choked up throughout this sentencing hearing multiple times, and you're about to hear it again as she reads the actual sentence.
Given all these considerations, and having carefully considered the comments of the family of both Daunte Wright and the comments of Kimberly Potter, as well as the arguments of counsel, it is the sentence and judgment of this court that you shall be committed to the custody of the Commissioner of Corrections for a period of 24 months. You shall serve 2/3 of that time, or 16 months in prison, and 1/3 on supervised release, assuming no disciplinary offenses or conditional release violations. You have credit for 58 days already served. Restitution will be reserved. There'll be a fine of $1,000 and a surcharge of $78 to be taken out of prison wages or due within 180 days. You must provide a DNA sample. You may not use or possess any firearms, ammunition, or explosives. You have the right to appeal the conviction and sentence. If you are unable to pay the cost of an appeal, you may apply for leave to appeal at state expense by contacting the state public defender. You may be seated, Ms. Potter.
Okay, so there's the sentence. No firearms, you heard the $1,000 fine. A couple of important things we're going to pull out. Okay, first, 24 months was her sentence, 2 years. She already has credit for 2 months, and she only has to serve on good behavior 2/3 of that time, which is 16 months. So 16 minus 2 leaves 14 months. Just over 1 year is what she's looking at serving, if, all goes well. Then when she gets out, she's got another 8 months of supervised release, which is like parole, probation with a parole officer, you get it. So that's what she's looking at, which many are going to say is too light of a sentence, but I think some will say that seems appropriate because it was a genuine mistake from someone who's a good person, who's a community servant basically for most of her life, protecting and serving the community, and she made one horribly tragic, fatal mistake. So maybe 24 months or 16 or 14, however you want to look at it, is fair. What I want in the comments from you, let me know what you think a fair sentence is, and you can just do it in the number of years. So 1, 2, 3, 4, 5, 6, 7. Don't go over 7 because that's what the state was asking for. So I don't want to hear people that are even harsher than state attorneys that are handling the case. So 0 to 7, let me know what you think a fair sentence would have been. So you heard something called restitution in there. Restitution will be very difficult in this case because they have to see what she owes the victim and took from the victim, which is very difficult in a criminal case and is kind of different than a civil case. But restitution coming from a criminal case does not mean there cannot be civil cases as well and civil payments as well. Two separate court systems, two separate numbers, two separate sets of rules, so that doesn't affect any civil lawsuits or settlements. And I don't know off the top of my head if the civil cases have already happened here. If they haven't, they will. But they may already be going on, I assume, at this point. I know Ben Crump was already commenting about how this was such an unjust sentence. So I'm sure he's involved in one way or the other. And then secondly, appeal. How does this affect appeal? She can appeal the conviction. She can appeal the sentence. If she does that, she runs the risk of losing this sentence. If she gets a new trial and gets convicted again, well, now she's at the mercy of the judge to decide the sentence. It may not be the same judge. Judges rotate, judges retire, cases go to different judges. So if she runs that risk, she could lose this sentence. If she wants to clear her name, that's one thing. But to me, she seems very apologetic, knows that she did something wrong. Maybe she'll just take it, serve her time, and then try to move on with her life. But almost more importantly and practically speaking, if you're only serving 14 months, how much of the appellate process can you really get done? Because you could be deep into it and then get released from prison. And at that point, do you really want to run the risk of doing this all over again and potentially getting more time? Or do you want to put it all behind you? So to me, the more important appellate issue in this case is if she only has to serve 14 months, it's going to be difficult for her to go through all of the appeals process before she's out of prison. So maybe she just serves her time, puts this case behind her, because 14 months is not long enough to go through all of the appellate options she's going to have in this case. So I'm really interested to watch that and kind of see what decisions and steps she makes now that she got a sentence that's a downward departure from the guidelines in this case. The judge thought the mitigating factors far outweighed the aggravating factors in this case. In fact, she thought there were no aggravating factors proved by the state, but that there were a ton of mitigating factors proved by the defense. So once again, another very interesting portion of a high-profile case. This sentencing decision by the judge was unusual. Her explanation of how she felt about the defendant was unusual, but yet the sentence seems kind of fair to me. But I can't wait to hear what you all think as lay people who could have been on this jury, who could be members of this community, how you would want somebody like this punished, if at all, for the actions of Kim Potter. So let me know in the comments. Make sure you like this video on the way out. But for now, that's all we've got. Thanks for watching this episode of The Lawyer You Know. If you like this content, please share it with your friends. Make sure you subscribe to our page and like our videos. If you want some interaction, get in the comments and we'll be sure to get back to you. If you want to know any more information about our firm or this page, you can find out in the description or visit tragoslaw.com. We post multiple times throughout the week, so make sure you hit that bell so you can get the notification and not miss out on the next episode.